All right, here we go. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for November 17th of 2025. Brad, go ahead.
Well, let's start with the shock heard round the world. And I was shocked. We're going to start in Whiteside County, Illinois, where a jury, meaning this went to a trial and it went on a question of fact. We'll talk about the legal issues in a moment, right? Remember, juries only decide factual issues. The court, the judge decides legal issues, and things only usually get to a jury if they've gotten past the legal issues, which we'll talk about with immunity, etc. But they've returned a verdict for $31.5 million in favor of a widow and the two young children of a firefighter who died in the line of duty by falling into a basement in December of 21. I would encourage all the listeners to do what I did because I looked at the OSHA report. It's posted on Curt's website, Fire Law blog. But look at the house, right? I was looking. So the part of the issue here is OSHA or state OSHA, but OSHA claimed that they didn't realize there was a basement there. And we'll go through the other issues, but the first question I had was, okay, would I have known there's a basement there, right? First chief arrives, does a full 360, walks around, maybe grabs the power and electricity, shuts it off, and looks for a basement or other doors. This is a single family, one-story dwelling, but for the basement with an internal staircase. Now, I'm not saying they weren't there. It's on one flat piece of land. It does not drop off in back, which you would normally say, okay, I can't see it from the front, but you can't see it from the back. But there apparently, I don't know if it was a full or a small crawl space basement. It looks like a full basement because there's a full staircase in the drawings. But when I looked at the back pictures, I didn't see any evidence of a basement, and I couldn't see any casement windows. So, we'll get into
Some
this,
of
but
some of that, but Brad, some of that is knowing your district. And like here in New England, here in Rhode Island, I've been a firefighter in Rhode Island all of my life. So most houses have a basement. So you make that assumption. Now you go to different parts of the country, and most buildings are on a slab. And I don't know about that particular venue, Whiteside County, Illinois.
it
Uh,
looks like it's on a slab, but it's not, obviously, but
Well,
it looks like
but
it.
some of it, and but that's one of the things you got to rule out. But I don't, I'm not sure. I mean, certainly that was relevant. If there was no basement, we wouldn't have the case. But
Right.
I think the accountability issues,
Yeah, so let's go through those.
the missed maydays, the lack of a par, just as important as missing the basement. I think those things just as important.
Right.
Absolutely.
So here's what we have, right? And we have an individual fell through the floor into the basement. They didn't know about the incident commanders didn't know about the basement. This is what OSHA's saying, the lawsuit's saying, and clearly the jury agreed with. There were two Mayday calls from the basement. Command officers, I guess the jury found, heard the Mayday calls, but couldn't understand or couldn't establish the identity, location, the nature. So a lot of departments use lunar, right, as a system: location, unit, name, accountability, resources, whatever. In any event, the lawsuit alleged that the fire officials were willful and wanton, meaning reckless, so more than negligent, more than grossly negligent, almost intentional. Recklessness is acts that's so dangerous it's almost intentional. In any event, they said willful and wanton, that they disregarded the safety of firefighters by failing to follow proper procedures, including interior command. I don't know what that meant because I would not have an interior command at a fully involved structure fire. Accountability, that's easy to see. Mayday response to the floor collapse and basement identification. That's why the basement identification, right? If you don't have a basement, a lot of this, not all of it goes away, but right, I couldn't tell there was a basement, so
Mhm.
I'm questioning what did they argue, right? Would the jury have known there's a basement? In any event, they do note, although I couldn't tell this, they do note that the lieutenant, the deceased, bore some responsibility because he didn't leave when his partner left.
Mhm.
Now, that cuts two ways, though, right? Because on a
Mhm.
PAR report, personal accountability report, which they claim they should have done, normally you'd be like, okay, where's your partner? Why didn't he come out with you? Where are you? And order him to come out. But the partners should know they come out together. So they gave him some responsibility. But Curt, do you know? So there was a $31.5 million award. Was it
Mhm.
reduced by some share of Lieutenant Ramos's own injury? Because I don't see what the reduction was.
Yeah, the news reports are not, they don't provide the kind of information that you or I or our listeners really would like to see. And I searched, I probably read like 7 or 8 different news reports on it. Much of it was just repeating the local news coverage of it. And no one talked about that issue. But I think there's certain, we call it contributory negligence. So, you know, uh, comparative negligence. So there probably should have been an offset for that. If there wasn't, I think the defense has some sort of recourse on appeal. Um, I really I think you and I really need to talk about what the distinction between ordinary negligence and what they found here, which was willful and wanton. And that term, I want to go over. Willful and wanton goes back to the 1800s, if not
Yeah.
earlier. It's an antiquated term. I think back in the day, the judges would say, you know it when you see it. But it's not really helpful in terms of trying to explain what it is. It's more than just negligence.
Right.
Negligence is not living up to the standard of care that's expected of that particular
Right. You
person,
didn't
the
act like
incident
a
commander.
reasonable firefighter would have acted.
Yeah. So, so the negligence is like if you think about like in my book I use Dante's Inferno. And I talk about, the layers of hell and like negligence would be your first layer of hell. And then you go down a little deeper, you're in gross negligence. Then you go down a little deeper and you're in reckless. And I think that's willful and wanton is down there in reckless, and then the lowest is intentional.
Right.
That's the worst of it. So what they're saying here is reckless, and I'm not sure. I mean, we don't want to see this.
No.
It's absolutely horrible that we see this, but is it actually reckless, which is consciously disregarding a known and substantial
And,
risk of
and
harm?
that's where I started with the basement. I
Yeah.
can't see the basement. It's not obvious. So anything related to falling through the basement,
Hmm.
which you didn't necessarily need, but right, how is it reckless? How is it
Yeah.
willful and wanton? And more than that, so let's stay on your topic. Let's go
Mhm.
through each finding
Yeah.
of right, and then say, well, was that willful or wanton? So
And
first is
I do want to, because I know I don't need any hate mail. I get plenty of hate mail. I don't need any hate mail. We're not saying that the fire department did everything perfect, or that
right.
that there was nothing wrong here. What we're analyzing is the legal standards that are being applied here that justify a $31.5 million verdict.
Which by the way, just on that for a second, is questionable. And yes, we're not
Mhm.
beating up on the right or the wrong. We're just talking
Mhm.
about the legal issues. But
Right.
31.5, now he's young,
Mhm.
right? And has kids, but he wasn't going to make $31 million over his time. Maybe there was pain and suffering.
Yes.
Presumably there was. That's a lot because he's
And
breathing.
well, let's explain
Yeah.
what you and I understand what you just said. But what you just
Oh.
said is when it comes to determining damages, the jury can't just pick a number out of thin air, or can they? They're not supposed to
Exactly.
just pick a number out of thin air,
Right.
but you have to show damages. Damages could be medical bills. They could be lost wages.
Which
And
is
when
the big
someone
number.
right? And when someone is killed, you have to figure out what their lost wages. And if you have somebody who's in their 90s that passes away, well, the very little lost wages, but
Right.
you have somebody who's in their 20s and passes away,
And
you
has a
have a whole
job.
right and has a job, you have a lifetime of wages. And certainly a firefighter's wages are you can calculate those, but they're going to differ from a doctor, they're going to differ from a mechanic, they're going to differ from an accountant. So you
Right.
need experts to come in and testify as to that. So they can't just pick a number out of thin air. But There's also probably some award there for pain and suffering
Conscious pain and
and
suffering. Yeah.
right, and loss of consortium for the family members and so on.
So the right and the conscious pain and suffering, there's a for everybody listening, there's a joke among lawyers, just a joke. This is not advice that if you hit someone and you seriously kill them, run back up and run over him again so it kills him because the longer he suffers, the more money, and there's big money for conscious pain and suffering. So a dead person's worth less than an alive person who then dies suffering, and there is all sorts of testimony at trial, as there probably was here, about how long was he alive, what was his suffering like. And here you can unfortunately imagine, or maybe you can't, how bad the suffering
Well,
would have
the terror, I guess they focus on the terror that he had. He was in there for 17 minutes between the time he called for help and the time they found him. So
Yeah, so all of those factors gave to 31.5. So that said, here's what they said. Let's go back to your reckless issue, because I think you're dead on for this. The first thing they say is there's no inquiry upon arrival about whether the structure had a basement, and they said the basement was unknown until the Mayday calls. Now, I don't think that's reckless. They're probably focusing on a lot of other things then, like resources, right? So my question would have been there, okay, well, what else were you doing when you arrived? What did you do a 360? Maybe you didn't even recognize that there was a basement, because that's what I would have done, a 360. But you're calling for resources, locating the hydrant, locating the electric and the power shutoff, asking if there's anybody in there. I mean, if you're doing a million other things and you forget one, that's not reckless.
that's not reckless. No.
And by the way, there's a reason Curt and I are doing this, because this probably is going up on appeal, where these exact questions are going to be asked of the jury. Let's predict it, right? So how are they going to say, well, they got to say what was reckless? They need one reckless act that resulted in the death. So that's probably not going to be reckless. Next one, failure to appoint a safety officer at the scene timely, despite a senior trained official arriving at 11:40, but an appointment not made until after the Mayday call at 12:03. So in 23 minutes, they didn't appoint a safety officer. Is that reckless?
Yeah, and many departments utilize either an additional responding chief officer as an aid to assist with radio
That's what I
communications,
did.
especially you're into mutual aid, you're trying to keep track of people. So, to willy-nilly say, oh, you're going to be a safety officer, and now I don't have an aide or I don't have anybody to assist me at the command post. Again, at most, that's negligence, and I'm not even sure that's negligence. So,
Agreed, right? Okay. Let's give three more. Failure to withdraw interior crews when fire condition worsened and holes floor collapse were developing. We'll talk about that. The fire had spread from the garage into the home and attic. So, jumping to the second part, there's no way anyone knew holes were developing in the floor because they didn't know there was a basement there. Right? So, and it's a single story. So you can't say that's reckless. They didn't know, and should they have known? But failure to withdraw interior crews when fire conditions worsened. Well, wait a minute. Worsened or were immediately dangerous to life and health? They're always bad. We're always in bad stuff. Right? You, me, and a million other firefighters have been pushed to the floor by heat, but that's why we've got a nice, tight, hose nozzle pushing out 150, 200 gallons a minute, and we're cooling the place, right? So how do you know it was dangerous? And did an expert testify? I presume so.
yeah, and I was thinking about this morning. What were the qualifications of the attorney that cross-examined the expert? And does the attorney even know what questions to ask? To really, ask the expert, how many Maydays have you handled? How many were successful? How many were not successful? What caused them? Okay. And, where is your credibility coming from?
Right. Right. I mean, I assume this started as a basement fire, and there's some type
I
of,
gotta believe they said it came in as a garage fire, but how does a garage fire get into the basement?
Right.
To the point where
unless
it's burning the floors in the basement.
Right. If it was on the same ground level, the slab or the floor, I don't know. It's possible, right? But it's not usual. So
I think they have a mistake, and they thought it was in the garage, but it's actually in the basement. How else
that's what
did
I
the
think.
floor burn out?
Right. I think it was the reverse. I agree with you.
Yeah,
It went right, and I don't know, and I haven't read that part. But in any event, that doesn't seem reckless, right?
right.
And crews, I don't know what the radio traffic was from the crews either, but they have an ability to report what's dangerous or not. So one question is, did Lieutenant Ramos and anyone else make a report? Hey, Chief, it's getting a little hot in here. We're not making any progress. We need to come out. The right, the chief is looking for that type of information and feedback from the interior crews.
Mhm.
So if Ramos didn't report or others didn't report, this is getting too hot to fight, then how is that reckless? Okay, failure to initiate a personal accountability report, PAR, promptly after the Mayday calls. My problem is this. The Mayday calls already happened. He's in the basement. Any expert would testify there's zero chance of getting him out of the basement. Almost zero chance. I mean, we
Well,
look.
here's my point. This is something that it's a policy driven issue here. When we have one firefighter calling a mayday, we absolutely, positively have to do a par. No
Absolutely.
excuses. You have to do a par because when you have one, and the same thing, if you have one firefighter down, if you've got one firefighter down and you get them out immediately, you still need to do a par because that could be the only indication that you have multiple firefighters down.
Right.
And when you have a firefighter down, you have a mayday, you have to do a par, and that wasn't done. Now, is that reckless or is it within, that first layer of hell, which is
Right.
negligence? And my opinion, it's negligence. It's not reckless. It's
And
it's negligence.
I agree with you. And what were the conditions of the basement? Because under your theory, see, it all
Mhm.
ties together. Your theory and mine, this probably started as a basement fire that went to the garage, not vice versa.
Right.
And at that time, 23 minutes into the incident, since it's already spread to the basement and created holes, was it even survivable in the basement such that a RIT team, it's a proximate
Right, and
cause
this
question.
approximate cause, absolutely, absolutely, and again, all these questions, and you wonder how. I don't know. I wish we could get a copy of the transcript of the trial. I know it would be laborious to go through, but I really think it would be helpful to the fire service,
To see the
and
cross
certainly for us in terms of
examination.
our ability to train firefighters and talk about this, if
Right.
we could actually get the transcripts.
Because this is scary. And lastly, failure to train personnel in maydays and pars. I agree that's probably negligent, but
Yep.
it is not reckless. And here's the thing: like I'm having a hard time believing that this person went through a firefighter course and wasn't trained in how to call a mayday.
Well,
It's part of firefighter one. Now maybe they didn't describe to must have policies where they have a
yeah.
mayday policy, right? But maybe they didn't have a mayday policy. Maybe they didn't practice it. Maybe they weren't good at the personal accountability reports.
Mhm.
But that's not reckless, to your point.
Right.
So and then the at trial, the wife says, I listened to my husband saying Mayday 6 times and no one does anything. That that's not reckless. Not
Mhm.
hearing someone. There's a lot of fireground chatter. In fact, I will say this. So in March 7th of '02, when my own two of our interiors, my department died and fell through a basement floor. So same similar circumstance, except it was a huge mansion. You knew there was basement, but we didn't hear the Mayday. It wasn't until a 911 operator, Mike Kramer, gets, I know this from 20 years ago, gets on the radio and says, "Hey, you got a Mayday." It happens, right?
It's
It
happened. It's
happens a
happened to
lot.
me. It's happened to me as the incident commander. It's happened to me when I was a deputy chief responding in with battalion chiefs. And there's something about it. I actually wrote a paper for the National Fire Academy, the EFO program, on this very issue, missing maydays. And there's a lot of science behind it. But as a deputy chief, I'm coming in. I got a battalion chief that is managing the incident, and I can hear the mayday, and he can't. Okay. Role reverse, I'm the incident commander and other people hear it as well. So that is another reason why we want to have multiple people. You got to have a system that assumes you're going to miss the mayday and has
Yes.
that backup. I think
Right.
that's the safest way to do it. Okay. But again, is it reckless?
I, it could have been caused by poor radio traffic. It could have been caused, like I have some places where you have three radios in front of you
Yeah,
and you're trying to monitor three radios because you're going to mutual aid or, whatever, or you're
only somebody who's never been there could suggest that that's not a problem.
right. That's exactly it. And look, we go back to the car dealership, New Hackensack,
Yeah,
New Jersey,
yeah,
right, where they didn't know. I mean, this
yeah.
is not a new problem,
No.
but it's not recklessness. So again, to avoid the hate mail going to you, I get very little of it because but we're not saying we don't have sympathy. We're looking at this from a legal perspective only, and from a legal perspective, I don't see this.
No.
I
I
really
did
don't.
look up the Illinois law. I got it right here on immunity, and they have immunity. The fire department and the firefighters have immunity for negligence, but not for gross negligence, recklessness, willful and wanton, and so on. So it was important for the plaintiff's attorney to make the case. And I think sometimes what attorneys are good at are increasing the drama volume and the tragedy of it to get the jury to say, "Oh yeah, this was willful and wanton,"
Right.
when in reality, in objective reality, um, it's more in the realm of negligence, I think.
It is.
But
And the definition in many states or most states for gross negligence is the failure to even attempt to be careful. Well, you can't tell me they weren't attempting to be careful. Now again, you and I haven't listened to the radio traffic,
right,
so maybe there's something more. But I want all the viewers. We should want all the viewers to know this is a very one-off situation. I don't know that we've ever seen anything like this. Usually there's a special duty, special relationship issue. Usually there's a legal issue on immunity, as there is here, sometimes stronger. And then here, I don't understand how they found they were willful, wanton, reckless. I just am not getting that. But again, we weren't in the courtroom. But I'm guessing there's going to be an appeal. I'm assuming the judge asked the defense asked the judge to set aside the verdict as against the weight of the evidence for
and that may still be
recklessness.
coming. We call that a JNOV, judgment
Yep.
notwithstanding the verdict, and that it's possible that could be coming as well. But and this, this is a tragedy. It's an
Oh,
absolute tragedy. Um, and I can't imagine, even if the fire department was found not liable and the firefighters were found not liable, that the department is just going to continue doing what they're doing.
right. There's
Certainly
not. There
when
was an
these,
ocean vest.
right, when, certainly, but to have a tragedy and then to compound that tragedy onto other people who were there trying to do the right thing for the right reasons doesn't necessarily help, you know. And
Right.
the flip side of this is another issue because I get asked all the time, do you have any cases where a fire department was held liable for blah, blah, blah? And you could have this same case. This case could have been dismissed based on immunity. The judge could have looked at it and dismissed it. Does that mean it's okay to do what this department did? And the answer is no. Like liability in and of itself isn't all that helpful in terms of directing what we should be doing. We should not be killing firefighters. That's what we should be focused on,
Right.
not liable or not liable. It's a different analysis.
But
And
it
and we shouldn't be doing this just because we shouldn't be taking these precautions. I'm looking at them right now. Identifying whether or not the building has a basement, appointing a safety officer, withdrawing crews when there's conditions are bad, initiating a PAR when you have a mayday, and training our people. We shouldn't be doing that because the fire department was liable. We should be doing it because it's the right thing to do because we don't want to see any more brother-assisted firefighters in caskets unnecessarily.
right.
So
Right.
anyway, I'll get off my
No,
stump.
no. And look, I feel obviously we feel for the family.
Absolutely.
She's one of our own, but I also feel for the department.
Yeah.
And now to have a jury to say basically you killed them, that's a hard pill to swallow. So,
Yeah.
and I'm not sure it's deserved. Anyway, okay. So that's 30 minutes on that. But a
Yeah.
great
Well, I do want to before I want to just put something up on the screen. Just a little bit of selfish promotion here, but one of our regular listeners brought some fire law, excuse me, fire
I love
law
it.
garb. He's is my good friend Jim Campbell, and Jim is out in Iceland. And so that's the Northern Lights. He's a little bit of a he's a firefighter, but he's also a little bit of a hazmaniac. And when he sent me the picture, I said, "Were you doing some sort of a hazmat exercise or something?"
That's
He says, "No,
awesome.
no, no. I'm in Ireland, but in Iceland, but he wanted us to be aware that he's spreading the word about fire law in Iceland." So
Throughout the
yeah,
that's great.
so
Okay, let's let's move on. So now we're going to head to North Carolina. This is a lawsuit, a federal lawsuit. We have the parents of a 6-year-old girl who died over Memorial Day weekend in 24. This is weird. There's two parts to this. So they've sued a lot of North Carolina agencies, including the Dallas Fire Department, which is in North Carolina, not Texas. And they accuse the Dallas Fire Department really of two things. But the second one, which we'll get to, is concealing the evidence of trauma and falsely classifying their daughter's death as an accidental drowning. Here's the first part, however, is so there's a sleepover. She's 6 years old. She's at a sleepover, and then she's found unresponsive the following day, right? So I don't know. Well, we'll see. And then she's transported to a medical center where she's pronounced dead. The EMS report documented a contusion on the anterior chest above the manubrium. I'm not even sure what that is. An injury to the plaintiff that was consistent with blunt force trauma. Now that I don't really understand that because what did she fall in the pool? Did she not? Did she hit her head
did
fall in the
somebody
pool?
try CPR?
Right. Well, and that's the point because it talks about the following day. So here's what the lawsuit alleges. The lawsuit alleges that regardless of the EMS documentation, numerous agencies involved omitted the chest injury from their reports. And the autopsy then ultimately lists the cause of death as drowning, though the plaintiff, people suing the parents, claim the medical findings didn't support that conclusion. So there's two things against Dallas Fire Department. One, you didn't provide life-saving care at the scene. And two, you didn't disclose or preserve the critical evidence. And with that, I am so confused exactly what happened.
Yeah, there's a racial component to this, I believe, as well, that it's not alleged in there. But there's apparently some community concern about it. And again, we don't
It's a
know.
kid. I don't care
Yeah,
what race. No way.
it's a tragedy. It's a tragedy. And the first thing I saw, blunt force trauma to the chest with a drowning. I mean, certainly there could be something nefarious. There could be, okay,
Good.
but chest trauma in a drowning, I'm thinking immediately somebody tried CPR,
Right. And
and
what's the motive to conceal it? Why they didn't kill her? Why would the fire department
uh,
try to conceal it
I,
unless this is the family member of one of their, I mean, you'd have to go through some strange hypothesis to determine
yeah.
why they would
Well,
conceal this.
to me, I think one of the takeaways from this is the importance of the report and accuracy in the report, and the fact that, certainly I'm sure the firefighters were, you know, affected by this, like any of us would be. You go to the
Right.
scene, and this is a traumatic incident, and sometimes we're thinking more about that, and we're not thinking about the details that we need to include in our report. And this, to me, I don't know who put it in their report, but or who omitted things from their report. But there's certain incidents that we really need to make sure that we're doing a good job of documenting.
Of
And
course, everything you see and observe and write, but that you personally see and observe. But here, what's the incentive for them to omit it? There's none
right,
that we know
no.
of. All right.
But that's
And
the point. When you're doing the report, you can't foresee what somebody else is going to include or not include. And
right.
then it looks like, you did something for the wrong reasons. And
Right.
so again, you can't outthink what other things are going to happen that are going to lead somebody who's upset already.
Well, let's assume they did. How did it affect the decedent? It didn't. And I'm going to sound harsh, she's dead. What they put in the report didn't affect her at all. There's no monetary value to that. Maybe a disciplinary issue,
Yeah,
right,
and
for the fire department.
it planted a seed in the minds of traumatized family members who want to find, like, it's a natural instinct in all of us that when there's a tragedy, when someone we care about has been killed, that someone must be responsible. And
Yeah.
uh, and it's predictable that folks are going to be in that mindset, so that when we have a fatal incident, we've got to be mindful of that. And it's not like preparing a report on a false alarm.
Right. Right.
That these are consequential reports that people are going to be looking over, and typos and omissions and other things can kind of come back to haunt you.
Now,
So,
there just as one additional note, and again, nobody should think Curt and I are trying to defend or prosecute anyone, right? We're just talking about what we see, what we read. But here, multiple agencies involved. The EMS report might not have been done by the fire department, right? Because there's a line. An EMS report documented a contusion on the anterior chest above the whatever, an injury the plaintiff state is consistent with blunt force trauma. And then the question is that what it says, the lawsuit alleges, your blog says that despite EMS documentation, right, various agencies included it. Various agencies then admitted it, or omitted it. So the EMS included it. Well, that makes sense. They're very precise. Head show this, eye show this, mouth show this, right? But a normal fire report might not go into that detail,
right,
because it might have been an obvious death where they're not stripping the patient down.
right,
EMS is putting on the leads to confirm asystole and death. Fire may not have been that involved, or they would have even seen it.
right, right. Yeah, so I don't know what would have been in the fire report that would have caused them to think the fire department either neglected to include that detail, or said something that indicated they were somehow responsible for not doing what they should have done.
And if they did, who cares? Or if they did omit it.
Yeah, I know. And again, all I could think of, going through it, is that we have a family who is just really hurt and upset that this happened, and they're looking for a boogeyman to blame for what happened. And beyond the family that allowed this to happen. I mean, if my kids are all grown up, but if one of my grandkids, this happened to one of my grandkids, I'm not upset so much with the fire department as with who let her near the pool, who wasn't
exactly
watching.
That's who you're suing.
So again, I don't know.
All right, well, let's get to, I'd like to say lighter topics. First two have been very heavy. Jesus.
Yeah, they have. Wow.
Yeah, even I feel depressed now. So let's go to Nevada. We have a firefighter, we've been so skeptical. Here we go again. But they file race discrimination, harassment, and of course the tag along retaliation. And here are the kind of the facts. He said that, and this is confusing. I'm just starting right up because this order he gets is confusing. So this guy Pavone, he begins the fire academy in February of 24. He's one of 78 recruits, 58 pass, I think. So he graduates in June of 24. He's assigned, now he's a probationary firefighter. So for 5 months, he had mostly positive performance evaluations, right? And they always do that to say there's no other reason why he would be terminated. So it's smart to do or say. And then he says that he was given a request, it's got to be a request, I guess, not an order, to shop while he's off shift. And Curt and I would give the same advice, which he says, which is, he said, I was told, and so I'm not going to work off shifts when I'm unpaid off schedule hours. Exactly what we would say. Now, I'm not totally sure that going shopping for lunch is considered work or a work activity, right? And certainly not going shopping for your own lunch is considered work. So shopping for other people's lunches probably also isn't work, but that was his excuse. And I'm not suggesting he should be a tax expert, but this is his alleged excuse. And
Or a
then he says,
FLSA expert.
yeah. And then, gee, if there only was one. And then he reportedly starts receiving threatening text messages from another firefighter that says he did not deserve to be a firefighter and, do what you're told. Now, stop here. If I said to somebody, okay, this person's now going to be harassed, the reason for his harassment would be what? You failed to go shopping, right? We told you to do it and you didn't do it. Yeah. End of story right here. But then it continues, and this is why they should be very careful what they include in a complaint. And if I was drafting this, and they start retaliating against him, moving his station, changing his schedule. I don't think they pled FMLA, but he said he was using sick time and then needed 3 more, hence FMLA, for 3 more scheduled shifts for sick time, and that he was criticized, he was sick, but he was sleeping at the station. It goes through all this stuff, and then enter race. He then claims, and we'll tell you why, it's not a horrible case. He then claims all of this was because of his race. So I say stop here. Go back to, they even said it was because he ignored an order. Right. Nonetheless, and I'm not saying this is or isn't because of his race. I don't know. We don't know. But he starts saying that other firefighters who were white were not treated this way, but another African American, another black firefighter, he was retaliated against, and then several other minorities were retaliated against. So now they are making out a claim of, okay, you treated 5 or 6, right, protected class of individuals based on race worse than you're treating the white probationary. Right, so now
you raise a great point. Is it about not going shopping?
Right. Did everyone who's white go shopping? And we don't know. So I don't know, that's where I am.
Yeah. Yeah, I mean that's a good point. When I was putting it together, I hadn't really thought about it like that, but you're absolutely right. Which is it? You can't be both.
Can't be both.
Is it because you wouldn't go shopping, or is it because of your race?
And if it started immediately after he wouldn't go shopping, if the retaliation, because he says immediately thereafter he starts receiving text messages, I'm thinking it's because you wouldn't go shopping. Now, unless they were trying to set you up, but so look, the issue is going to be, how do they treat similarly situated white probationary firefighters? I mean, that's really what's going to happen. But they allege race discrimination, hostile environment, retaliation, and they don't do FMLA, which with 3 days of sickness, and they could have probably thrown in a Family Medical Leave Act, maybe, depending on what he was sick for and out for. So that's what that is, and that's kind of unique. You and I really poke holes in things. Curt, I'm accusing you of making me sarcastic. I think this has done this for 3 years. Okay, let's go to
material. It's the material.
Yeah, it is. So now this one is just bad. But we have 3 former North Carolina fire officers, from a chief to, I think, a deputy or assistant, to a captain, right? We have a chief, a deputy chief, and a captain here, and they've been indicted following a joint investigation that looks like they intentionally deleted information from computers or made it impossible to get to. So they allegedly, they erased the hydrant mapping system. They erased, let's see, and that was down for 2 weeks. They got rid of or blocked Knoxbox system access. I don't know that that's usually a problem because there's a key, so I'm not sure what the issue with that is. Yeah. And then they said there were hazmat docs for local businesses which were withheld or deleted, which compromised public safety.
It might have been their pre-fire. I'm thinking it's their pre-fire database, which is going to have the location where the Knox boxes are and information about it. And I think on some of the Knox boxes, I think you can get them with passcode. So it might be the passcode. I don't know, but there may be some alternatives that have passcodes. But it seems like there was a transition of leadership in the organization, and when the outgoing folks left, they decided that it was their prerogative to disable or obscure, make it difficult to access
Or
this
it wasn't, and
information.
they didn't do it. Or maybe they just wanted their names off of it, so they removed their own credentials, right? Leaving people without being able to, connect. But
Access it,
the
yeah.
the reason I'm being a little negative, because well, I am on every case so far. Why not continue it? Is this is such stupid stuff
Mhm.
to retaliate and try to
Yeah,
disable. What's
yeah.
the motive here? If you're going to do something else, you might get rid of physicals or personnel records or policy manuals.
Mhm.
Why hydrants?
I can't speak to that, but there is something unusual here in that there was a press release by the town of Stanley, and the Stanley Police Department that basically detailed all of this information. And I know several other news media outlets were covering this. Within a day of or two of me posting it, it was taken down. Yeah.
Wow.
And so I'm
The
not
the
sure
Verone
why the
impact.
town would have decided to take it down, but they took it down. And unless it's back up, I checked it yesterday, it was still down. So I'm not sure why they would have done that. The North Carolina State Bureau of Investigations and Gaston County District Attorney have not put up any press release on it. So the only press release on it was taken down. Uh, so I did include that the news video, and hopefully that's still, yeah, it looks like that's still there. But
It's just I just don't look. If you're going to retaliate, you do something that hurts the department, not the people. And I look. I don't know these people. I'm not defending them. I'm not prosecuting them. But it just doesn't make sense to me. It seems like there was something else. Like maybe we removed our credentials and now you guys can't log in.
well,
Or
they got an indictment, so obviously it went to a grand jury. It wasn't just the police department charging them. So there
no,
must
but
have
it's
been
the
something.
DA who gets to testify without the defendants there. Gets to say whatever he
Yeah,
wants.
yeah.
Grand jury's like a
You're right. You are very cynical.
I am, and well, especially of grand juries. I got to
Yeah,
testify before a grand jury once. It was
yeah, me
it
too.
was fun. I mean, but it's a joke. They'll
Yeah,
indict anyone.
I like it. No cross-examination.
Exactly, and the defendant's not there. There's no other side. This is your view of the world. And
Yeah.
anyway, okay. Lastly, and I can't even believe we're still covering this. But I guess they're wrapping up. So we have a federal court now who has dismissed, and everyone's going to go yawn. I get it, a COVID vaccine mandate in Los Angeles, California, by their employees. Look, this is one of now 500,000 different cases which have said be as creative as you want. 1981, 1983, religious freedom, medical freedom, freedom of association, pick one. That there's no protected right to refuse vaccine, not have that information reported to who got it. And the court, the Ninth Circuit, who's a liberal court anyway, let's be fair, but in this case, the case was dismissed. The court said that COVID vaccine mandates were subject to a rational basis. Doesn't say at the time, but that's what most cases are doing now, saying what we knew at the time.
Right.
And they said it's not a strict scrutiny basis as a constitutional violation. And they found that the city ordinance that they challenged was rationally related. It's a very easy test to a legitimate government interest to prevent the spread of COVID-19. And so they cite a prior decision that ruled that vaccine mandates, as we've seen many of, do not violate substantive or procedural due process and do not violate equal protection clause. And as I said, do not violate a million different constitutional mandates. So this is one of the last ones that is saying goodbye to your COVID lawsuits.
Yeah.
So
All
I don't
right.
think we need to spend too much time on that.
No, we've had a bunch of them. I just a little bit of a unique twist on that one, but certainly the same outcome that we've seen in virtually all of, not all of them, but very few of them have actually prevailed. So
Yeah. And look, I'm not I got the COVID vaccine, but as people
mhm.
know, I've talked about my law partner died shortly after he got the vaccine at a trial. He was in the trial. The hospital refused to do an autopsy, despite the fact that autopsies are required by law when you're in a trial. So yes, I am skeptical of the vaccine generally, even though I got it.
I hope we don't get another strike.
Oh, God
Um,
forbid. No, I think
yeah,
YouTube's
yeah.
better now, hopefully.
Well,
But
hopefully
we
YouTube is better. And at one time, for saying what you just said, we would have
oh
gotten a
we
strike. We
it,
absolutely would have gotten a strike. And I think this was a interesting discussion of that first case. It'd be a shame if the whole thing got taken down. But hopefully now
nah,
we're
that,
in a different world here. So
we hopefully are. But yeah, so the viewers know, we once said the COVID word. We started calling it C,
yeah, we couldn't even
and
use the word. You'd
couldn't use
get
the word.
taken down on YouTube. Yeah,
And we were reporting a court case, and they took down the episode. So
yeah.
in any event, it's recorded. But that's all we got.
All
That was
right.
a heck of a session.
It was. And that's going to do it for another edition of Fire Law Roundup. We'll see you all next week. And if you've stayed this long, please click like, please click subscribe. And that helps us a lot in terms of the algorithm. Our numbers are continuing to go up, and it's really because of your participation. So we really appreciate it. And that'll do it.